Hello, everybody, and good evening. This is Sushovan Dhar from India Labour Line and also from Working People's Coalition. We welcome you all to this edition of our 4-part lecture on the new labour course that will be implemented very soon, which has already been passed by the Parliament, but will be implemented very soon. The previous week, we had a lecture by Professor Babu Mathew of National Law School, University of India, on the Industrial Relations Code. So today we have with us Advocate Gayatri Singh, who's a senior advocate in the Bombay High Court and who has been engaged with the workers' issue for the last many decades. And so she will be speaking on the Wages Code 2019. Just before we begin, we say that this violation of wages, a systematic violation of minimum wages, wage theft, these are a recurrent feature in the Indian labor scenario. It's already a precarious situation. So we did a study about the implementation of minimum wages in Delhi, and we found out that 75% of the workers in Delhi are forced to work in very indecent work and unsafe working conditions. 95% have no minimum wage. There are similar studies which show that across South Asia, workers lost around $25 million during the pandemic. There's an app, Project Hero, which came up with a report in January 2023, which says that 10% of the construction sector workers are paid minimum wages in India. So we will have Advocate Gayatri Singh speaking about it. So let me welcome Advocate Gayatri Singh, and please, without much ado, I pass it to her to speak about the Wage Code 2019.
Good evening, everyone. I am not able to put on my video. I don't know, there's some problem with my internet here. So please excuse me. I don't know what's happened. But I'll just start with the Wage Code, which has been in public domain and public discussion for a long time. The Wage Code also has undergone a number of drafts. The first draft was in 2015, and then there was a draft in 2017, and finally the Wage Code was notified on 8 August 2019. And the rules, the central rules, were framed in 2020. So basically, since it's under wages, labor law is under concurrent list, both the state and the central governments have the power to frame rules and acts pertaining to labor. And in this context, once all the states frame their rules, then it gets into the implementation phase. Right now, some states have not yet framed the rules, but because there has been a lot of agitation and protest against the provisions in the Wage Code, all the 4 codes have unions and organizations have protested against these, and now they have been stalled for some time, and it appears that it might be passed in phases soon after the elections. And that is why I think that it is very relevant that we discuss these issues, so everybody knows about some of the very draconian provisions that have been enacted in all the 4 codes. Now, as far as the 4 codes are concerned, they overlap each other, and the best situation would have been that we combine all the 4 codes and have a series of discussion on that. But since they would have taken a lot of time, we have broken it up into separate sessions. Today we're going to have a discussion on the Wage Code, and I would try not to make my lecture too long so that there is an interactive session and people interact and raise issues or comments on the Wage Code. So basically, as far as the Wage Code is concerned, it amalgamates 4 acts: Minimum Wages Act, Payment of Wages Act, Bonus Act, and the Equal Remuneration Act. And as Babu Matthew also spoke about the Industrial Relations Act and the amalgamation of various acts, the government stand is that we're doing this in order to simplify the labor laws and make it easily accessible and implementable as far as these acts are concerned, as far as the codes are concerned. But if we look at all the four codes, very even at a superficial level, we find that most of the protective clauses or entitlements or rights which the existing acts have extended to the workers have been taken away under the codes. And we will deal with all the four acts, that is the Minimum Wages Act, Payment of Wages Act, Bonus Act, and the Equal Remuneration Act, which basically are amalgamated in the wages code, and which basically take away, it's just basically 2 or 3 provisions from those acts which have been added on to the wages code. Now, as far as the Minimum Wages Act is concerned, we are all aware about the Minimum Wages Act. It's been in existence since the time of independence, and basically it emerged from a focus on sweated labor in order to provide those workers who were outside the ambit of collective bargaining some sort of a modicum of wage security. So we find that it basically introduced scheduled industries, and any of the industries which were scheduled under the Minimum Wages Act were basically specified the minimum wages for that particular industry. And if we look at the wages, the minimum wages that were fixed under the Minimum Wages Act, it basically overlaps with starvation wages. So it was really, it introduced minimum wages, yes, but it was basically continuance of low wages, high wage inequality, working poverty, and high gender wage gap. So these were some of the problematic issues which existed under the minimum wages. And we find that even as far as the scheduled industry is concerned, these minimum wages were never really revised. So one, they were extremely low wages based on starvation wages, and 2, over a period of time, those wages were never revised nor adjusted to cost of living index. Now, as far as the wages code is concerned, before the code was notified, there were a series, as I said, there were a series of discussions and drafts that were circulated, and people did submit their objections. There was a standing committee which went into all these issues and recommended certain changes in the code. However, those recommendations were never introduced in the final draft that came about in 2019. But before the 2019, a committee was set up known as the Anup Satpathy Committee, which was set up in 2019, and it submitted its report. It was constituted in 2018, and it submitted its report in January 2019. Now, it's very, very important to look into some of the recommendations that were made by the Satpathy Committee, because some of these recommendations were carried forward into the wages code, and many of the unions who have been demanding higher minimum wages based on a fair wage and linked to the cost of living were actually considered by the Satpathy Committee. But ultimately, those recommendations were thrown out of the window, and a fresh committee was set up to look into these issues in terms of setting up the criteria for determining minimum wages, a national minimum wage. Now, as far as the Satpathy Committee is concerned, it basically was directed to determine the methodology for fixing the national minimum wage. So basically, since the fixation of a national minimum wage formed a part of the wage code, the Satpathy Committee was given this task to look into the factors which would be used to determine the national minimum wage. Now, the committee basically relied on two recommendations. One was the 15th Indian Labour Conference of 1957, which basically outlined a need-based minimum wage. And for calculating the need-based minimum wage, the following factors were taken into consideration. One was the consumption units. So what would be the consumption units? It was determined by the 15th Indian Labour Conference that it would consist of 3 consumption units. One was normally, it was the male worker who was the breadwinner, then the spouse and 2 children. So basically the unit for 2 children was 1 and the 2 were the spouses, and therefore that was taken into consideration as 3 consumption units. We'll go into the fallacy of this consumption units because it gets carried forward in the wage code also. The second consideration or criteria was that each consumption unit would need 2,700 calories, 15 grams of protein, and 30 grams of fat per person. Then, in addition to that, was the clothing that was required, which according to them was 72 yards of cloth. And thirdly, was the fact that food and lighting would also be taken into consideration, which would constitute 20% of the 20% of the calories, that is food, plus the clothing and plus the rent. So rent was also taken into consideration based on the rent which was applicable for the low income category of people. And lastly was the question of the 20% food and lighting. So this basically constitute the criteria for determining minimum wages, and that was what was used while calculating the same. The second criteria that was adopted by the Satpathy Committee was the findings in the case of Raptakos bread in 1992, which basically expanded this concept of the criteria that was set up by the 15th Labour Conference and included education. I'm not going into the percentage, etc., but it included education, health, old age pension, and other miscellaneous factors for recreation like marriage expenses, etc. So this basically was the criteria used, and the Satpathy Committee, just to shorten the whole discussion on this, the Satpathy Committee came up with a figure of 375 rupees per day per person. So this was the minimum wage that was fixed by the Satpathy Committee. Now, if you look at the national floor wage, it is not as if the Satpathy Committee set up this national floor wage for the first time. It existed way back in 1990 when the floor wage was 20 rupees per day. It got extended to in 1996 to 35 rupees. And finally in 2017, it was extended to 176 per day, which came to 5,280 per month. Now, this basically was really starvation wages and were figures which were well below the poverty level and were based on rural data. So basically, these national minimum wages were based on the findings of the National Commission of Rural Labor recommendations. So one, they were starvation wages, and two, they were not based on the urban population, but more on the rural population. Now, this 375 became the recommendation made by Satpathy Committee, which was given to the government and which was to be included in the wages code, but ultimately the central government did not accept the recommendations, mainly on the ground that the recommendation of 375 was too high, and it should be, though it was never publicly known as to why the Satpathy Committee report was not accepted. So now into 2020, as another committee has been set up, I'm not really aware what has happened, because they have been given a 3-year period to come up with the findings based on the same issue relating to the national floor wage, which is, and the criteria used to determine the said wage. So the report of January 2009, which was submitted, ultimately within a 3-month period, the notification came out notifying the wage code in August 2019. Now, in between, the Standing Committee on Labor, which basically heard the unions, employers, the state governments, and the central government on this issue, submitted a detailed report, and I think everyone should have a look at it, where all these objections were considered, were looked into, and ultimately the committee recommended drastic changes in the wage code, which were never really introduced. So let us go now into the wage code, and I'll just deal, there are many issues, but I just deal with 3 broad issues. One is the coverage. How many people, who does it cover? What categories of workers does it cover? The third is the mechanism used for determining the national floor wage, not the minimum wage, but the national floor wage, which is to be set up by the central government, and the minimum wage, which is to be formulated by the state governments. And the third issue is the issue of enforcement and implementation of these various provisions. So as far as the coverage is concerned, it basically does away with all the this concept under the minimum wages with regard to the fixation of minimum wage based on the industries which have been covered under the schedule. So most of these industries, as we all know, are industries where unorganized labor are employed. They are really sweated labor, and the wages that were fixed, as I said, minimum wages, basically constituted basic wages and dearness allowance, which were far below the poverty level. So in effect, it did away with the scheduled industry concept, and it covered all the workers, whether they were in the organized sector or in the unorganized sector. This is the propaganda that is spread by the government in saying that this code is much more progressive, and it has a larger coverage. It covers more than 7 crore workers, etc., etc. But if you look at the definitions under the wages code, and I'll just cover 4 main definitions. So the first is the definition of employee, which basically says that an employee who is earning wages, who is employed on wages by an establishment to do skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, or a clerical work would be considered an employee. Now, the problem here is one, that though it covers even technical managerial, administrative staff, it really excludes a large number of workers because it says that an employee who is employed on wages by an establishment. So you must be employed in an establishment to be covered under the code. So you have problems with regard to domestic workers. They are not covered in an establishment because if we look at the definition of establishment, we find that this whole concept of establishment is a narrow definition where it says that it constitutes any industry, trade, business, manufacture, or occupation. So a domestic person working in a household would certainly, that household would not be an industry, it would not be a trade, it would not be business, etc., etc. And therefore, a large part of the unorganized sector are really outside the purview of the Wage Act. You also see it in the context of the definition of worker. So you have a definition of employee, you have a definition of worker. Now, what was the need to have these two separate definitions? I am not able to figure out why these two separate definitions were put in to confuse the implementation of the act even further, because the worker definition is slightly different from the definition of employee. A worker is defined as any person employed in an industry. So again, you have to show that you are employed in an industry, and we all know that the whole concept of industry has gone from, even though it was explained under the ID Act, basically there was a lot of litigation on the concept of industry. Even today, a full bench is hearing this matter before the Supreme Court to determine what exactly is the definition of industry. So a worker is any person who is employed in an industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work. So basically, it limits it excludes persons who are working on an administrative capacity or in a managerial capacity, which are covered under the definition of employee. So it is a restrictive definition as compared to the definition of employee, and it basically includes two other categories, which could have been included in the definition of employee also. It includes the definition of, it includes a category of journalists as defined under the Working Journalists Act, and it includes sale promotion employees who are also under the Sale Promotion Act. So basically, these are the two additional categories which have been used under the definition of worker. The employee definition is slightly broader, and the supervisory category under workman, again, is as per the ID Act, which restricts it to a person who earns salary less than 15,000. So this use of employee and worker, if you look into the wages code, you'll find it being used discriminately in different places. For example, an employee is used under section 6, which basically is a much broader section. We'll go into that. And a workman is used under different sections. So again, it gives a lot of scope for the employer to exclude a number of categories from the definition of employee and worker. Secondly, if we look into these new categories that have come up, like gig workers, platform workers, most of these workers would be excluded from the wage code because of the definition, which excludes a large part of workers who are not able to show that there is an employer-employee relationship. For example, Anganwadi workers or scheme workers, these would also be excluded. So these are the three very important definitions which basically encapsulate the provisions under the wages code, and it does not cover all the workers. It in fact excludes a large number of the unorganized workers. The fourth definition is the definition of employer, where again, I will not go into the exact definition, but the employer is again a confusing category because it basically excludes contract workers, and what is the concept of a principal employer, the liability of a principal employer, etc., are actually taken out of the definition of employer, where the contractor becomes the direct employer and is held responsible for payment of wages. Whereas under the existing laws, it is the principal employer who is responsible. And finally, the concept of, or the definition of wages, where basically the definition has been narrowed down to include basic wage plus dearness allowance and plus retainance allowance. If people do not know what retainance allowance is, we can discuss it during the discussion period, but it's a very small amount depending on the allowance that is given to workers who continue to remain an employee of the industry even though the industry is not working. So it's a very, very small amount. So basically we look into basic wages and dearness allowance. Now, so this is as far as the coverage is concerned. The second provision, important provision, is the provision relating to the fixation of the rate at the fixation of the national floor wage and the minimum wage, which is to be fixed by the state government. This is the central place or the fulcrum of the wages code, because everything really revolves around these provisions. So the first part of that is our section 6, 7, and 8, which basically deal with the manner in which the state governments will fix the minimum wage. Now, this in itself is very problematic, because what it does is, what it says is that it is the appropriate government. Appropriate government is defined under the code. We will not go into that, but basically whether it's state government or central government, which will determine who decides on the fixation of the wages. So basically section 6 says that the appropriate government will fix the minimum rate of wages which is payable to employees in accordance with section 8. Now, so the first part deals with giving power to the state government to fix minimum rate of wages. How should this minimum wages be fixed is really not very clear. Even if we look at these three provisions, 6, 7, and 8, basically 7 says that the state government can look into the fixation of minimum wages by considering only the basic wage and the DA, or it can take into consideration basic wage plus DA and the allowance and the cash allowance which is given to the workers in lieu of wages. We need not go into this provision, but the most important provision is section 8, which basically says that in fixing the minimum rate of wages for the first time, or in revising the minimum rates of wages, appropriate government will do two things. One, it will appoint various committees to look into this issue for fixing the minimum wages. And two, if it does not want to go through the route of appointing committees and going through their fixation, then the other route for the state government is to issue a notification publishing its proposals and seeking information from the public. So basically, these are the two routes by which the state government can fix the minimum rate of wages. But it does not say how that minimum rate of wages should be fixed. What should be the criteria for fixing the minimum rate of wages? Nothing is said, and that is why many of the unions and labor organizations really waited for the rules, thinking that maybe in the rules there would be more clarity. But this has not happened, and I'll come to the rules subsequently, because as far as the committees are concerned, it was earlier suggested that the committees would consist of equal number of employers, employees, and state representatives. But this has not really happened, nor is there any provision to show how employees representative will be taken in. And what it looks from the code is that it is the state government that will decide who these representatives will be. So that the question of consultation, which is most crucial in deciding how these wages or wage rates should be formulated, it becomes totally redundant, because you do not have representatives from employees who can be part of the decision-making process. That is one problem as far as the consultation is concerned. And the second part, it looks as if the government will adopt the second route, which is basically through a notification and seeking suggestions from the public. And then within 3 months, within a period of 3 months, the notification becomes final and it gets notified. But in the second route, the state government must take the advice of the advisory committee. Now we'll come to the advisory committee, because an advisory committee has to be set up both by the central government and by the state governments. The advisory committee again has representatives from employers, employees, state government, and independent persons. Again, the manner in which the employee representatives are going to be appointed, it's clear that it will be on the basis of what the central government decides and who the central government decides to nominate as employees representatives. If we come to the rules now, the rules, basically rule 3 has a heading which says manner of calculating the minimum rate of wages. The manner of calculating the minimum rate of wages are are basically the same recommendations which have been made by the Satpathy committee. So it has a standard working class unit, which is basically the male worker, the spouse, and 2 children. Then it has a net intake of 2,700 calories. Then it has the cloth, housing rent expenditure, which again will be 10% of the fooding and clothing expenditure, fuel, electricity, etc., which would be the 20% of the minimum wage, and expenditure. Now here, this is important because it says it excludes some of the recommendations made by the Reptocos judgment. And it says that it will include only children's education, medical requirement, and recreation. It excludes a large part of the wages, which is basically old age pension, and all these, that is medical, children's education, and old age pension, constituted 25% of the total minimum wage. So a large part of the social securities, which was what was directed under the Reptocos judgment and by the Satpathy committee. I have problems with the Satpathy committee also in terms of deciding the calorie intake, the consumption unit, but taking that as a basis, many of those recommendations have not been included in the manner of calculating the minimum rate of wages. So this is basically what the rule says. Now, again, if we look at the rule, we find that it is very, very arbitrary. It's arbitrary in the sense, how do you decide who the 3 consumption units are? For example, if we look at women who work in the household, we all know that that is unpaid labor. It is not recognized, it is not visible, and that is not, women's labor is not taken into consideration at all while calculating the standard consumption unit. Secondly, the children, which is kept at the level of 2 children, which many families, it might not be correct to determine the consumption unit as only 3. That in itself is problematic. The third issue is with regard to calories. Everything revolves around the manner in which you determine the calories, which is not really a correct way of determining what is need-based and what should be the fair wage. So many of the other aspects with regard to non-food items have not been taken into consideration. I'll stop at this with regard to the fixation of minimum rate of wages by the state government. And as we've seen, it's very, very problematic. The second part of this provision is the fixation of the floor wage by the central government. So what it does is basically it seeks to set a national floor wage, which will be set by the central government. Now, there may be states, for example, if the central government fixes the national floor wage at the rate of, say, 5,000, and many of the states have fixed the minimum wage at, say, 6,000, then there is a provision in the code which says that even if these states have fixed a higher minimum wage, the higher minimum wage will stand and they cannot decrease it or lower the minimum rate. I mean, that is one good provision, but the problem is that, again, how do you really fix the national floor wage? What is the criteria? What is the mode in which it is going to be done is absolutely vague and is not at all clear, even if you look into the rules. So basically, Section 9 says that the national floor wage will take into account minimum living standards of a worker in such manner as is prescribed. So it will take into consideration the minimum living standards. What are the minimum living standards? Would it be the lowest living standard, which, say, a worker in an unorganized sector is getting? And what would be the criteria for determining the minimum living standards? That's one. And two, it leaves everything to the future or to the subjective will of the central government when it says that it will be as prescribed, because the rules have not prescribed the manner in which this minimum living standard is to be determined. So now if we come to the rule, the only rule which gives some explanation to the manner of fixing floor wage is Rule 11. Here again, it is the advisory board that should be consulted before fixing the minimum wage. And it must take into account minimum living standards, including food, clothing, housing, and any other factors considered appropriate by the central government. So again, it leaves everything to the will and whims of the central government, who will decide what will constitute a living wage. So though they mention food, clothing, housing, and any other factors, nothing is really said as to how these different categories will be calculated, what is the amount that will be reserved under a particular category, and what would be the final calculation of the national floor wage. So really, the word that is used is the floor wage and not the minimum wage, which it should be. The national wage should be a minimum wage and not a floor wage, because the concept of floor wage is basically depressed wages, take into consideration the lowest and the low of the minimum wages that is being paid to the workers. This is basically the second part in terms of fixation of minimum wages and the national floor wage, which will be set up by the central government. Now, if we look into the Equal Remuneration Act, because the Equal Remuneration Act has been done away with, and let us really look into the act, because the Equal Remuneration, though it had many faults in terms of implementation, problems of defining the different categories and definitions, the Equal Remuneration Act basically provided for equality in terms of work and in terms of wages and in terms of recruitment. Now, under the Equal Remuneration Act, recruitment basically included promotions, training, and transfer. The present act basically includes only the wage differential, which is basically defined. The wage differential will be decided on the nature of work, which should be same work or work of a similar nature. Now we know the problems that existed under the Equal Remuneration Act. These words were very vague. There was always a problem with deciding and defining same work or work of similar nature. For example, a very good example is of the air hostesses case, where you had the pursers who were male and the air hostesses who did the same work, but because they were designated separately and differently, the Supreme Court held that they were not doing the same work or similar work. So there has been a lot of such cases under the Equal Remuneration Act. It basically, this wage code carries forward the definition of what is there under the Equal Remuneration Act, but excludes some of the important provisions. As I said, it does not include the various forms of recruitment which should be looked into when you're considering discrimination on the basis of sex or gender. So, I mean, even though they say that it's been combined with the Equal Remuneration Act has become amalgamated, it has taken away many of the provisions. The second most important part of Equal Remuneration Act was that a committee was to be set up, and the committee would consist of 50% of the people who were on the committee were supposed to be women. Now, in the advisory committee, which I mentioned very briefly, under the state government and the central government, you have representative of employees, but the women representatives would be only 1/3 and not half of what was there under the Equal Remuneration Act. So again, the question of consultation, the question of involving women who are able to explain the intricacies of how they are being discriminated has really been taken out of the wage code. And finally, you had a provision in the earlier draft that with male, female, the word transgender was also included in the first draft. However, in the final draft, the word transgender has been removed, and the findings of NALSA judgment, which were given in 2014, where transgenders were considered as third gender, that has been excluded from the wage code. And finally, I'll just take 10 more minutes. Finally, we have also there are no provisions to prohibit discrimination in employment on the basis of caste, religion, or social origin. So it basically does not even take into consideration caste discrimination and discrimination on the basis of religion. Finally, we come to the third category, which is basically the enforcement category, enforcement provision. But before I come to the enforcement provision, there is also a provision which says that the wages should be fixed or revised every 5 years. This is a similar provision which existed under the Minimum Wages Act, but we know that there have been under the Minimum Wages Act, there have been no revisions for many of the scheduled industry. A similar provisions is carried forward in the wage code, which basically says that the wages should be revised every 5 years. Now, the problem here is that if we look into the past history of the various states, we find that Delhi revised its wages after 22 years. So in most of the scheduled industries, Delhi, in fact, revised it after 22 years. Maharashtra revised it after 9 years, and so on and so forth. So you have a situation where the states are actually dragging their feet in terms of revision of the wages. Now, basically, as we saw, basic wage and dearness allowance forms or constitute part of the wages. So the states basically, by not revising the wages, justified it on the ground that the DA, that is dearness allowance, was being revised every 6 months. So as we all know, there is a provision which says that the DA, in order to neutralize the cost of living, the DA by the state governments, the DA will be revised every 6 months depending on the cost of living. So the argument of the state governments is that we have been revising the cost of living every 6 months, and therefore there's been a revision in wages. But what must be looked into is not the DA that anyway will be revised. It is the basic wages that need to be revised, because that is what constitute the living wage, as we saw in all the earlier committee reports. The second part of this revision is the problem with regard to consumer price index. So basically, as I said in the beginning of the my presentation, was that the national minimum wage already existed way back in the 1990s, where basically it set up the national minimum wage at a very at below poverty line, basically. And the CPI that was used on the basis of what was there for the rural laborers. So you have a CPI for agricultural laborers, you have a CPI for rural laborers, you have a CPI for industrial workers, which is known as CPI IW, and you have a wholesale price index. So there are different levels at which the consumer price index is fixed, and that has not been taken into consideration in the wages code as to how you will determine the CPI with regard to different categories of workers. However, there is a provision in the wages code which says that the state governments, while fixing the minimum rate of wages, will take into consideration the skill of the workers, the arduousness or the difficulty or the hazardous nature of the work, and the geographical location. So, but again, we are in a federal government. I mean, with the power and authority to decide that should also go to the state governments. But the wages code says that it is the central government which will issue a notification regarding the geographical area of these, with regard to how these wages should be fixed. So basically, there are three different categories of geographical locations. One is a metropolitan area, second is non-metropolitan area, and the third is the rural areas. This, which area, say for example, Bombay, would it be metropolitan? I mean, that's a clear case where it would fall under metropolitan. What would be non-metropolitan? What would be rural will be decided by the central government. And the second part with regard to the skill of the workers, that also will be decided by the workers. So under the Minimum Wages Act, you have three categories: skilled, unskilled, semi-skilled. Here, in order to decide which categories would come under skilled, unskilled, semi-skilled, the central government will decide. And already in the wages code, there is a schedule which sets out the different categories which would be considered as skilled. Again, if we look at those categories, they're absolutely subjective. There's no rational basis on which the categories have been decided. Many categories have been left out. So basically, these are the categories which will be considered as skilled, unskilled, semi-skilled. And in order to decide further categorization, a technical committee will be set up. Now, this technical committee, again, does not have any person, any representatives from the workers. It basically consists of state and central government representatives. And finally, now, if we go back to the enforcement provisions, this is the most draconian, in the sense that though everything centers on consultation, the the enforcement, we find that the mandatory provisions with regard to inspection have been removed, and inspectors, the role of the inspectors has been removed, and now they're termed as inspector cum facilitator. So basically, the role of an inspector was to make visits, random visits or surprise visits to certain factories where they could investigate, they could summon witnesses, they could look into the documents, registers, etc., and take action against the employer. So they had the power to take action against a defaulting employer. Here, that power has been taken away. all that the inspector cum facilitator is required to do is to provide advice with regard to the provisions of the Act to the employer and the employee. So if he or she knows that the employer is actually violating the provisions or is not complying with the provisions of the code, all that the inspector is required to do is to call the employer, advise them, and then ensure that he or the employer implements the provisions. If the employer does not implement, he has no power to take action, but the state government can take action by appointing another officer to look into this issue. So basically, this person has, the facilitator basically is supposed to facilitate the implementation, but has no powers to take any action against the employer. Now, we have what is known as the ILO Labor Inspection 1947, which is number 81, which I think everyone should have a look at. Not that I'm not saying that ILO is the final authority which we must look into, but they set certain guidelines. And particularly when the central government is refusing to look into many of the suggestions that have been given by the unions, the ILO resolution, which is ratified by the Indian government, it basically says that the government should ensure that the legal provisions of various, whatever act that is legislated, the legal provisions, it should ensure that the legal provisions are enforced. It must relate to the conditions of work, protection of workers, hours of work, wages, safety and welfare, employment of children, young persons, etc. So basically, enforcement of legal provisions relating to the conditions of work and other provisions relating to hours of work, wages, safety, etc. are important provisions, and they must, the government must ensure that these legal provisions are enforced. The second part of the resolution basically says that the inspection staff should be independent. It should have a number of labor inspectors. They should be ensured that traveling expenses are paid so they can make visits to the places concerned. They should be allowed to enter freely without notice to the employer. They should take steps to remedy the defect, and they should have executory powers to take action against the employers. These are the provisions which exist, and all these provisions have been taken out of the wage code, where basically the inspector cum facilitator has absolutely no powers to do anything, including inspection, where basically it is based on website inspection. So basically, the inspector can just sit in his office, open his net and see which company is implementing or not implementing the provisions, and then submit an inspection report on the online without actually visiting the site. So these are very, very dangerous provisions. And in fact, just as in the Occupational Health and Safety Code, all the powers of the inspector have actually been removed. And this is mainly for the benefit of the employers in the context of ease of doing business. And finally, we come to the question of offenses and penalties. Here again, the offenses, the extremely stringent offenses that existed under even the Minimum Wages Act have been removed. And basically what it does is it says that the first offense which is committed by the employer for non-payment or reduction of minimum wages, the maximum punishment is 50,000 rupees. So basically the criminal liability has been taken away and the focus is only on civil liability. So you have payment of compensation, 50,000 is nothing if you're depriving wages. As Sushovan says, there's been theft of wages in crores all over the country. And so violation of wages, non-payment of wages is a serious offense and should incur criminal provisions also. The second part of it is that if the employer does it violates the provision several times, more than say 2 or 3 times, then it is increased. The amount is increased, and the employer can be imprisoned for 3 months. So that is the only provision. And non-maintenance of records, etc., which was a serious offense, there the punishment is only of 10,000 rupees. So basically, criminal liability has been taken out, and civil liability of a small amount of payment has been introduced. And finally, I'll just end by looking into 2 more acts. The Bonus Act, which basically again is amalgamated, and it really does away. It should have just done away with the Bonus Act. I mean, there was no point of saying that the Bonus Act has been amalgamated, because what it does is there are 2 major problems with the introduction of provisions under the Bonus Act. One, that it exempts new establishments from payment of bonus on the basis of trial running of any factory. So basically the argument is that if a factory is freshly set up, it will have to undergo a trial running, and therefore during that period of time, there's hardly any production, and therefore bonus cannot be paid. Whereas under the Bonus Act, 8.33% was a right. Whether you were making profits or whether you were not making profits, the workers were entitled to 8.33%. This has been removed, and a new establishment can be defined as any, for example, under the old act, there was no concept of new establishment. For example, what the employers did was, if they set up a factory, say in Thane, and subsequently they closed it and set up a similar factory in Pune, according to under the wages code, that would be a new establishment, and therefore that employer would be entitled to not paying any bonus for the first 5 years, for the first 5 accounting years, and thereafter for the 6th accounting year, 7th accounting year, and 8th accounting year. So for 8 years, there was no liability, and ultimately the employer can just shut the factory and start somewhere else, and that would be a new factory. Whereas under the old Bonus Act, no such concession was given to employers, even if they change the name of the company, even if they change the location of the company. So this is one part which takes away the rights of the workers. And as far as allocable surplus is concerned, there was a provision in the old act that if the company is making profit, then the workers were entitled to a commensurate bonus, which could be anywhere between 8.533 to 20%. But that again, if the employer challenged it, the workers could go to court and ask for the production of the balance sheets of the company. This was a right which the workers were provided for, and they could not only challenge but question the manner in which the balance sheets were prepared. But here under this code, workers are not entitled to challenge the balance sheet. They have no right to get copies of the balance sheet. So they have absolutely no idea as to how the surplus has been calculated as far as the surplus allocable is concerned. And finally, as far as the Payment of Wages Act is concerned, Payment of Wages Act basically dealt with the right to a worker to get his or her payment on time, and that no illegal deductions should be taken place. Here, there are 2 parts to the code. One is it basically says that the workers, yes, should be paid on time. But as far as the state government employees are concerned, there a notification can be issued and they are not liable, the management is not liable to make payments to the workers on time. They could make any excuses for inability to make the payment. That's one part. The second is, as far as the deductions are concerned, their deductions can take place to recover losses, which was not allowed in the earlier Payment of Wages Act. So losses can be anything. The management or the employer can charge the workers for discrimination, etc., for violating any provisions of the law on the ground that they have caused damage to the company, and therefore the wages can be deducted. The second part was the performance of the worker. So for example, if the worker is unable to give the required production, there can be a deduction, which was not allowed in the earlier act. And thirdly, there is a provision to recover advances, which was not allowed. And this question of recovering advances has been dealt with a number of judgments by the Supreme Court on bonded labor, which basically said that an employer could not recover the advances given to an employee because that would constitute bonded labor. However, this draconian provision has been provided for under the code. And so I'll just end my thing so that we could have more discussion. Yeah, so there are a lot of problems with regard to the wage code, and I think each section we can go on and on many of the provisions, but this is just the overarching critique that I thought should be discussed. Thanks.
Thanks a lot, Gayatri. We have some time for question answers. The first two question is from Satyamurti. Could we use the GDP of India to fix the minimum rate of wages? That's the first question. The second one is by Chinmay Nayak. How can we ensure that workers are protected from the trend of casualization of labor, particularly in terms of guaranteeing a living wage? Additionally, what are the main challenges that arise with implementing living wage policies, particularly for the informal workers? These are the two questions which has come to us. Rajesh Upadhyay, another question by Rajesh Upadhyay. What should be the criteria of calculating minimum wages, in your opinion? Please explain the difference between minimum wage, living wage, fair wage, and floor wage. So we have three questions for the moment.
So as far as the first question is concerned, yes, minimum wages. So basically, even in the ILO convention of 131, which basically is a convention regarding minimum wage fixing convention, which has not been ratified by the Indian government. It basically broke it up into two parts for fixation of minimum wages. One was that the needs of workers and families, taking into account the cost of living, social security benefits, and the relative living standards of other social groups should be taken into account. So basically, this was the broad understanding with regard to fixation of wages. So basically, taking into account the needs of the workers and the families and the cost of living, because as I said, even in our Indian context, the cost of living is not 100% neutralization. It basically leaves much to be desired, because it really does not neutralize the cost of living, even the CPIs. Then you have the social security benefits. So we have what is known as healthcare, old age social security. All this should also constitute part of the calculation for minimum wages, which our country does not do that. So basically, as far as healthcare is concerned, is not included in the minimum wages. As far as old age compensation is concerned, it is not included. And that's where we look at the at the economy of the country. That is, what is the gross national product of the country, and based on that, what percentage of it really goes for social security benefits, as like in the case of other countries. We have the lowest percentage going for social security benefits as far as India is concerned. And then the second part of the calculation deals with economic factors, level of productivity, etc. So this is really a general category, whereas our Indian categorization, as I said, is really on food intake, consumption units, etc., which form the major part of calculation of minimum wages. And all these other aspects have been excluded. So I agree that even while calculating minimum wages, we need to look at the gross national product of the country, and on the basis of that included, particularly for the unorganized sector. Then, yeah, so that's the first. As far as casualization is concerned, I think it's a very, very big topic, and all the acts which really, some of the acts which provided for some protection to the casualization of workers, like, for example, the standing orders, and also the Contract Labor Act. I don't want to go too much into a discussion on that, but basically the Contract Labor Act to some extent protected the workers. This also has been done away with under the different codes, and so therefore that's one part. And secondly, as I think in the Industrial Relations Code, this might have been discussed, fixation of contracts, time fixation of contracts. That is, a contract will be fixed for a particular period of time. That is also a specific category which has been introduced, which will really increase the casualization of workers. And finally, what is I think the third question was criteria for calculation of minimum wages. Now, again, I mean, I've just said that this should be the criteria in terms of, but that needs really a sort of a calculation that has to be worked out by experts in terms of how we fix the minimum rate of wages. And what the code does is, it really does not help us in fixing that minimum wage.
Thanks. We have another couple of questions. You have mentioned about a report submitted by the unions and a suggestion that we must read it. Minnie Matthews want to know where can we read it? What is the report called? That's number one. There's another question about the ILO. I mean, somebody wants you to clarify about the ILO guidelines on enforcement and inspection. So yeah, these are the questions.
So it's called, to Minnie's point, it's called the Standing Committee on Labor 2018 to 2019. So you will get it on the website of the government. That basically has some of the objections of the various unions. It does not include all the objections, but some of the objections which the unions had raised. The second question was about, what was it? Yeah, about the ILO. So that ILO convention, is that person asking me about the minimum wage fixation convention?
Yeah.
Yeah, so I just read out some parts of that minimum wage fixation convention, which was in two parts. One was that the criteria for fixing the minimum wage should be, one, on the basis of the living wage, and two, on the basis of the economic factors and level of productivity, etc., of the country. but connected with this was another question, which I'll just answer, is the difference between minimum wage, fair wage, and living wage. So minimum wage is really it includes, I mean, not only the starvation wages, but according to the Supreme Court judgments also, it includes many other aspects aside from food. As I said, it includes even social security benefits. The fair wage is really a fair wage between, it forms part of the minimum wage, and also at a higher level, it forms a part of the living wage, which is really dependent on the capacity to pay of the industry. So if it's at a higher level, that is, if we consider the definition of living wage, it is basically something which the industry should be capable of paying. So that, and minimum wage is something which the industry has to pay, irrespective of whether they make profits or losses. I mean, that broadly is the definition of the three concepts.
Okay. There's another question that there was a sweeping mention of technical committee in the code, which will work on advice of central government. The question is that committee also dealing with the problem of fixing minimum wages?
Yes, so that is really the confusion, because though the code gives certain powers to the state government in fixing the minimum wage, it really the entire I wouldn't say burden, but the entire decision-making process is left to the central government. So basically, many of the concepts which, for example, the decision about who is a skilled worker, who's not a skilled worker, which is the geographical location, which type of work is considered as hazardous, underground work, etc., etc. All these decisions, which actually the state government should have taken, is left to the central government. So the central government will basically, as I said, issue a notification with regard to setting up of a technical committee, and that technical committee, unfortunately, I don't have the code with me, and I don't have a hard copy of the code. But if you look at the provisions under the code, you will find a provision regarding the responsibility of the central government to set up a technical committee, which will consist of equal number of employers, no employee. It will consist of state government and central government representatives and so-called technical experts. It does not explain who these technical experts are and how these people will be appointed. So that is one problem. And the second, as I said, it also will have the power to issue a notification with regard to the demarcation of the geographical areas into the three categories. So the purpose really is to reduce the number of different wages by reducing it from the 1,000 or 2,000 categories which existed under the Minimum Wages Act to say 3 or 4 categories under the wage code.
Thanks, Gayatri. Are there any more questions? There's a question by Minnie Matthew, which is the ILO guideline on enforcement inspection?
Yeah, that is ILO Labor Inspection 1947, number 81.
Okay, thanks. I think Chinmay has also typed it in the chat box. So in case there are now no questions, we will wrap it up now, end the session for today. We'll also like to remind you that we have another 2 webinars on the labor codes, the one on social code on social security and the other on occupational safety and health. So we will be sending our announcements very soon. Please feel free to join, spread it amongst your friends, colleagues, and others. Thank you very much for your participation today. And thanks a lot, Gayatri, for patiently explaining the whole wage code and the evolution of the minimum wages in India, the whole question of whether minimum wage or starvation wage, the question of low wage, and giving us various references of a number of legal instruments and other documents of international covenants and other documents. Thanks a lot. Looking forward to see you in the next webinar organized by Labour Access.
Thanks. Thanks.
On the labor codes. Thank you.
Thank you.